Great, thanks. Thanks for all three papers. Is this working? Yeah. And I've actually got a question to each of the presenters. The first one is to Martisa, and I agree that's a really important project to ensure we have expert witnesses. And I'd also suggest or ask, do we need also to introduce training for expert witnesses in going through evidence in chief and also taking them through training for cross-examination? So that's my question to Maritza, beg your pardon. And then to Paul, I agree that there are different jurisdictions and laws can be different in different jurisdictions, but I also wanted to ask whether what we need to work on is uniform legislation, because ultimately we want a universal definition of mobbing, for example. And there are some, and do we want criminal law, or do we want civil law, or do we want both? So I think there are some aspects that can be universal and cross jurisdictional boundaries. And then to Sandra, I was wondering, Sandra, what's happened in many countries like the United Kingdom and Australia is that universities have turned into businesses. They're actually not really educational institutions anymore. They're businesses. And I know that in Australia, vice-chancellors want to be called CEOs. They don't want to be called vice-chancellors anymore. So do you think this move to the university as a business may impact on the issues that you're raising? Thank you.
Well, let's address them with Maritza first.
Okay, so the question with regards to whether we need training, and including for cross-examination, yes, definitely. And so what I hoped with my presentation and hopefully get my paper ready and accepted for publication in this specific journal is that I want to start doing that training through our writing. So, and I'm open to working with others who are interested in that. My training, of course, would be in the US and specifically the federal courts. But I think that that's part of what we have to do. We need to start developing the expertise, the experts that are going to be able to qualify for expert testimony. And then, you know, with beyond the expertise, once we have people who are interested in making a commitment to becoming experts in this area, then I think that the training would be helpful.
Thank you.
Okay. Sandra, would you like to answer the question?
Sure. Sorry, Paul.
No.
The same thing that is happening in the UK and Australia is also true of Canada, where neoliberalism has overtaken the academy. I think we're just maybe half a step slower than everybody else, but not much. And there's this move to the corporate university. I don't think the question is, will it impact? But it has already impacted everything. And it's like one example, for instance, is ethical reviews. When they get subject to corporatization, then there's a whole list of processes and procedures that you have to go through. And so the same thing happens with every policy that's established. It's not good enough for us anymore to talk about academic freedom. It has to be defined and regularized, and what is and isn't academic freedom. And honestly, if you can support a legitimate scholarly opinion, anything should be covered by academic freedom. It should be okay, in fact, to disagree with your dean's or supervisor's research if you have a scholarly and legitimate reason for doing so. So I think that it's just going to be more rules and more procedures, which is something that makes me kind of anxious when we talk about the need for further definitions and the need for regularization. On the one hand, I fully support that because you have to fight fire with fire. But on the other hand, I mean, what is it? If it walks like a duck and talks like a duck, it's probably a duck. And so Interestingly, the question that you've raised is what my research has been focused on for the last, well, since 2014. And unfortunately, like the professor in question in my case analysis, I have been highly critical of my own institution and others in public press.
Thank you. Thank you, Sandra. And I think your question to me actually was sort of two different questions together. The first that I parsed out was whether you use the term universal law rather than state by state. So I'll address it from the American perspective, because part of the problem is, even if there is an international definition, the U.S., even as a signatory to the UN, doesn't abide by all of the laws, and the U.S. doesn't follow the International Court at The Hague. So in many ways, the idea in U.S. jurisdiction of having an international law can be very, very much ignored.
But if we just introduce it in the jurisdictions that we're in, we all agree.
I see what you're
there's
saying.
a definition. Yeah.
Right, yeah. Yeah, so I think that's a different question than should there be an international or universal law. Now I see what you're saying. The second question was, should it be housed in criminal law or labor law or civil law? I think, again, that varies jurisdiction to jurisdiction. That has come up in the lobbying that we've done in New York for the anti-bullying law. The original bill was placed in labor law. I did have a discussion with one of the state legislators about moving it over into human rights law. And there is actually a different bill that's circulating in the United States, which I think originally was intended to be housed in civil rights, human rights law, as opposed to labor law. Some of it will have to do with the mechanism of the law itself, the investigatory and the possible sanctions. But it is actually an issue that has been discussed about where does this kind of law actually belong. So, yeah.
There's some online questions too.
Sure, why don't we do an online question?
So we have one from Ileana Ramirez. Excellent presentation by Maritza Reyes. Are there preferred law journals to establish expert witness methodology?
So yes, we have because if we want the audience to be judges and lawyers, for example, then you go to what we call the law review journals. And for lawyers and law professors, that's usually the journals where we publish. With regards to what I'm hoping to do with my first article on this topic right now, and what I presented is to reach out to the type of community that we have here, because we can't get to how to do we promote it within the legal community to lawyers and judges until we have the expertise, right? Until we have people who are ready and prepared to be expert witnesses in this area. And so right now, I think we need to develop that expertise. I'm only speaking with the US model in mind. I don't know how it happens in other countries, but I think that right now it's about developing the expertise. We have to develop the next Dr. Kenneth Westhues. I wish he would start like a school or like a training, right, on how to develop the next experts in the area. And then as part of that training, we can provide the legal training to just have the knowledge, not to practice law, of course, but to at least have the legal knowledge. So I think that the journal that we are starting right now, I don't know what the capacity is in terms of, the articles, but I think that's a good way, at least for what I'm trying to do right now.
I'd like to offer a sort of counter to that, and I'm not trying to argue against or undermine what Professor Reyes said. From my perspective as a lobbyist, my experience has been no legislator would read any of our articles. When they have asked Mike and I and Tom, our colleague, for information, I gave him a 4-page white paper. And he said, no, 1 pager. And so there's this tension because as Professor Reyes said, we need the rigor, we need the length, we need the meat. But then in the legislative process, that goes way over their heads. So there is a tension there.
And just quickly, if I could add, remember I said the audience, right? And
Yeah.
so those of us who are in different, like my article right now is about developing the expertise. The lobbying article, for example, which I hope to do also, the 1 or 2 pages, that would be a different audience and so different approach. But right now for me, the impetus is to start to develop the expertise, because I am concerned what happens, when researchers like Dr. Kenneth Westhuse are not longer doing the research. We need to develop the clinicians who are going to be able to provide this expert testimony. So I think that all of us can look at the audience and do it in different ways.